Good evening and welcome. Normally on such occasions, the first thing we have to do is show you the exit door, but since you're all sitting comfortably in your own homes, then we have to skip that. My name is Julian and I'm the Assistant General Secretary of the NUJ, moderating from Dublin. You're very welcome to this Zoom meeting for NUJ members. Convened to talk about the risk to all of us as professional journalists posed by Julian Assange's potential extradition and conviction. As you will know, the extradition hearing sat for 5 weeks, and defence and prosecution are currently preparing their closing statements. They'll be delivered in writing, and the decision will be handed down in Court 1 of the Old Bailey on the 4th of January. Tonight is an information session. It is intended to shed light on a subject where a lot of heat has been generated. And hopefully, I think by the end of the evening, we will have a better idea, not just of this case, but the context for freedom and for all of us. There were 2 reasons for limiting the attendance tonight to NUJ members. The first is that this is the first kind of meeting that we have organised of this type. So my first plea is be kind to my mistakes. We felt it was necessary to limit the numbers to management proportions. Secondly, we thought that it was useful, in view of our own policy on this issue, to have an informed discussion among media workers, among journalists, NUJ members, so that we could discuss this case. The format will be 3 speakers. We will begin with Alan. We will then have Tim. And I think then Jen will bring us up to date on many of the issues and many of the questions, which will answer many of the questions which we have. The panel will invite speakers to speak for between 10 and 15 minutes. I think 10 would be preferable, but I'm aware that there are complex subjects to be covered. All of you who are listening have the opportunity to join in the conversation online, to put questions, and I will do my best to put questions to the panelists. I think at the end of the session, preferably, but if a question comes up that I think might be put to an individual panelist after they're finished, I will do that. So without any further ado, I'm going to introduce Alan. Alan Rusbridger edited journalist between 1995 and 2015. During which time he steered the paper from being Britain's great liberal broadsheet to being the world's great liberal news platform. During the time, The Guardian was the founding member of the Media Alliance that published WikiLeaks material, as well as bringing Edward Snowden's revelations into the public domain. Alan is the author of numerous books, of which his 1985 History of the Sex Manual is among the least well known, and which may well be the reason why he was chosen as a member of the Commission on the Future of Media in Ireland. The Guardian has been pivotal in the unfolding drama surrounding WikiLeaks. The Media Alliance that brought us all of this information was a powerful development for which those of us interested in media freedom would be forever grateful. And I think there is no better person to begin this story tonight than Alan Rusbridger. Alan, over to you.
Well, thank you very much, Seamus, and thank you to the NUJ for organising this. I'm pleased it's happening because I think I've got personal experience over the years of the curious absence of debate about some aspects of national security reporting and the lack of agreement about what constitutes the public interest. And I think there's a broader question that hangs over whether national security reporting will be possible in the future, especially if the decision goes the wrong way over Julian Assange. I felt this most acutely in the reporting of the Snowden regulations, when there was I would say a marked contrast between the attitude of the British press, which was by and large cool, if I can put it like that, in rallying to the support of the Guardian, and many other parts of the world where editors I greatly admire completely saw the value of what we were doing and why the Guardian had to be defended. So I think there is a curious confusion about national security reporting, and I would say there's a confusion about the extent to which journalists in this country should be rallying to figures such as Julian Assange and Edward Snowden, very, very different figures. Now, yes, the Guardian worked with Julian Assange on for a period of time, and we worked in a consortium of papers that included the New York Times, Der Spiegel, Le Monde, and El País. And I think we all went into it, into that partnership, knowing that there could be trouble down the line over what we were doing, of course. We worked as carefully and responsibly as we could. I include Julian and WikiLeaks in that too. And we went into it with the commitment that we would stand shoulder to shoulder if any of us got into trouble over that. And nothing that's happened since has ever led me to doubt my own commitment to that pledge at the time. And for a long time, it looked as though no action would be taken against Julian Assange. But then suddenly this move to extradite him came along, and I found it very disturbing in and of itself. And I also found the muted response amongst journalists puzzling and disturbing. The reason why I found it disturbing was that at least in the way that the charges were initially framed, he was accused of doing things that journalists do. And so I think we really have to try and take off our blinkers about whatever we may feel about Julian Assange personally, or about these intractable debates about whether he's really a journalist or not. The answer to that, he is sometimes. He does journalistic things, and some of the things he does are not so journalistic. But he was accused of doing things that are essentially journalistic. So one was, he was accused, he had an amazing source who was giving him amazing information. And he was accused of trying to get more information. Well, I can think of lots of journalists that I know who are lucky enough to have amazing sources, and say to them, "Look, I would like more documents like this." If you hear a strange hiccuping noise in the background, that's a puppy. It's not me. And so I think I'm not clear on what basis we would not support somebody accused of doing that. I'm conscious that Bob Woodward was rather critical of the Guardian and our behavior over Snowden on these grounds, that Snowden left his position and then gave us lots of information. And he said at the time, this was 2013, I would have said to him, let's not reveal who you are. Let's make you a protected source. Give me time with this data. Let's sort it out and present it in a coherent way. So he would have preferred Snowden to stay in place. So Bob Woodward, one of the greatest investigative journalists of our age, would have gone on milking him as a source and using his documents. So that's a journalist saying, well, I would behave actually in a way that would certainly keep my source in place. And the second thing Julian was accused with at the time was trying to, and again, there are different versions of this, but he was accused of trying to access a US computer. I think his story, but Jennifer Robinson would be able to tell us, was actually what he was trying to do was trying to help Chelsea Manning conceal her identity. And again, that seems to me something that you would hope all our reporters would do, that they would if they were lucky enough to have a source who was coming up with high value information in the public interest, that you would owe them a duty of protection, and certainly would try and stop them from being identified by their employers. So there were two of the charges, the two main charges that Julian initially faced. I thought that he was wrong to be charged in those terms, and that many journalists would behave in a similar way. I mean, there were strange other things that he was charged with at the time. He was accused of communicating through encrypted devices with Manning. Well, all journalists do that. That they took measures to conceal Manning as a source. Well, we've done that. I've talked about that, and so on and so forth. So this was a worrying case, and I respected greatly the lawyers I've come to know through Snowden, particularly James Goodall, who did the landmark Daniel Ellsberg case for the New York Times, when he said, look, you should be sitting up and paying attention to this, because if he is done for this, it's going to be bad for all journalists. I think someone who speaks with as much authority as James Goodall is someone who deserves to be listened to. And he's actually repeated, he's written repeated articles about the threat of this case. The second thing that I found worrying about this case is the fact that what was happening was that an Australian journalist was being accused in British courts of breaching the security laws of America. So just pause and think about that. I may have to lift this puppy onto my here's the puppy, completely adorable, but a bit noisy. So he was accused of breaching American secrecy laws. Well, there are a great many British journalists who have over the time written about Pakistani or Indian or Israeli nuclear programs that would be clear breach of domestic secrecy laws. And I wonder what we would feel if the Pakistani or Indian or Israeli governments came to Britain and said, actually, that person shouldn't have written about our secrets, and we want them to come and serve some time in our jails. So the sort of basic, rather shocking nature of what was being demanded, I found worrying. Although further charges were added, which I think present added difficulties. And again, I haven't followed the case completely because it actually hasn't been meticulously reported. And again, Jen Robinson could correct me, but I'm not sure that I heard any evidence of harm. And I was interested when Chelsea Manning herself stood trial that we didn't hear much evidence of harm following from the disclosure of these documents. But to the contrary, I think we could all agree there was a great deal of benefit. So that's why the framing of the case, I think, should be of interest to journalists. And the British journalistic community should have been taking a closer interest in all this. And I'm pleased that the NUJ has and is. But the wider context for this is that there's no doubt that after the Snowden revelations, there was a feeling in the so-called Five Eyes that we couldn't have this kind of journalism going on in future. We saw the extent to which Theresa May, as Home Secretary, saw through the enshrining in law of a lot of the things that Edward Snowden had revealed. But I think more as worrying was the fact that the Law Commission suddenly was asked or took it upon itself to look at the Britain's official secrets laws. And the relevance of this is that, and again, I'm sure Jim will talk about this, that the way that extradition works is that there must be broad similarities of laws in both countries. And this follows on from the Australian government already clamping down on severely on the way that national security journalism is done, including the premise that the government of the day should have the right to define what national security is, what the national interest is. And in the first version of the Law Commission's attempt to really make national security reporting, I think, almost impossible, they talked about it being an offence to receive material, so not even publish it, but just receive it. So if somebody leaked your document, whether or not you published it, you could be guilty. There was this thing that the government would define what the harm to national security was. Well, I mean, anybody with a sort of O-level in national security reporting, or any notion of the history of the press in Britain for the last 300 years, would know that the government is the last person who ought to be determining what the public interest is. I mean, just think of the Daniel Ellsberg case, when Ellsberg was revealing the secret history of the Vietnam War, which the government had kept from people. And when the Washington Post and the New York Times started publishing those documents, the Nixon administration tried to stop it, saying this is not in the national interest. This is treason. And they went to great lengths to nobble the papers, and they went to the Supreme Court. And there was this wonderful ringing endorsement from the Supreme Court, and James Goodall was there at the time, saying there's a greater view of national security and the national interest, which is not to be determined by the government. So they told Richard Nixon to go pack himself. That national security there was a broader definition of that. You couldn't injunct newspapers. And today, Daniel Ellsberg is a fluffy, snowy-haired 80-something-year-old, and we all think he's a hero, but he wasn't. At the time, he nearly went to prison for what he did, because a crooked president, as it turned out, wanted to define what the national interest is. So for the Law Commission to come out and say, well, it should be for the government of the day to define what the national interest is just legally and constitutionally illiterate, and we ought to be really worried by that. Then they're proposing a vast increase in jail terms. We also know, because the NUJ has done a lot of campaigning work on this, that it's increasingly difficult to keep the relationship between journalists and source confidential. The government has again said, actually, we don't regard this as something that's confidential, despite decades of precedent when those kind of relationships were regarded as beyond the grounds of the state. So you put all that together, and it's clear that what they're trying to do is outlaw national security reporting, and that cannot be healthy. And anybody who's familiar with the American notion of national security reporting, which is much more aggressive than what passes for some national security reporting in this country, will know how dangerous this is. And the final thing I think that disturbs me about this case is that even though the Law Commission has actually come back with it's taking a long time. It took about 2 years to consult on its initial draft. And it's come back and actually done something rather significant, which is to put into its new proposal that there should be a public interest defense to these kind of disclosures. So that's never been there before. It was one of the faults of the Espionage Act, is one of the faults of the original Official Secrets Act, that anybody accused of it could not say, well, hold on a minute, this is why I did it. This is the public interest that I thought it served. So you've got this proposal to change the British law to include a public interest defense. And yet Julian Assange is being threatened with extradition under a law which would not allow him to any kind of public interest defense, and nor, by the way, would Edward Snowden. If Edward Snowden ever went back to the US, he would not be able to explain to a jury why he did something. And that seems to me a fundamental missing thing. So at the time when the law is in such flux in this country, because obviously I think most journalists listening tonight would not need convincing that the Official Secrets Act is a ropey old thing that is past its sell-by date, just at the point when it's going to be rewritten in some ways, in ways that are bad, the government defending national security, the offense to receive material, but also with one little good thing in it, which is the possibility of arguing a public defense, a public interest defense. It seems very unfair on Julian Assange to be extraditing him while this law is in flux and hasn't yet been settled. So I suppose in summary, what I'm saying is we all have our opinions of Julian Assange. We all have our opinions of the extent to which he answers to the conventional and historic notions of what a journalist is, what a journalist does. But I think as a journalistic community, we should be coming together in a more full-throated way and saying, this is really disturbing, and that if we stand by and let this happen to him, it is going to have huge implications for people who want to do independent, inquiring, investigative journalism about things that the state would rather keep secret.
Thank you very much, Alan. I'm reminded in your descriptions of the official secrets of a case which the NUJ in Ireland took involving Liz Allen, who was a freelance journalist, then with the Sunday Independent, charged with a breach of the Official Secret Act. And the great Irish editor Douglas Gageby, who himself had served in Army intelligence, was an expert witness called by Allen and the NUJ. And he was asked, what is an official secret? And he said, in my experience, an official secret is something the state doesn't think you should know, and the state believes you shouldn't know anything. And I thought it was as neat a summary of how state governments perceive the official secrets. Alan's point, I think, is that we don't always have a choice in who we choose as heroes or martyrs, but we do have a choice in the principles that we defend and stand up for. And the NUJ has been doing that in this case. And the person who has been most active on our behalf is Tim Dawson, who is the union's immediate past president, who was an observer on behalf of the NUJ and the International Federation of Journalists during all of the case. And his coverage was extremely comprehensive. I think the Morning Star was probably the only newspaper in Britain that covered it. I was going to say religiously, but that sounds odd. Certainly comprehensively. I don't know what it did for their in terms of their circulation, but it certainly was an important function. And I would also encourage people to look at Tim's coverage on the NUJ website. Just to remind those of you who have joined us that at the bottom of your screen, if you're using your laptop, there is a Q&A function, and put in your questions there. And Gemma has asked two questions which Tim might address in his remarks. One is, what was it like in your general perception of the case? And the other question, I suppose, covering the case is, what is it that the NUJ can do for Julian? So Tim, over to you, and to no pressure in answering that. Unmute yourself there.
Thank you. I will do my very best. It's intriguing, and I guess you've both alluded to the extent to which Julian Assange is quite a divisive character. You can look for evidence of that if you want in the tweets of Donald Trump, who in 2010 called for Assange to be executed, and then in 2016 tweeted that he loved WikiLeaks, and then in 2019 tweeted that he didn't know who Julian Assange was. And while I'm not really suggesting that the general population shares that kind of weird apparent schizophrenia, it is certainly the case that one experiences really quite dramatic variations of opinion. And certainly as somebody who has coordinated some of the union's campaigning around this issue, I marched with the NUJ's banner from Australia House to Parliament Square, I think in February, and was repeatedly accosted by people who wanted to have a go at me, either in my capacity as a representative of the mass media, or because the NUJ in general and the trade union movement were perceived as not having done enough. But then I'm very conscious that we have members who feel uncomfortable about the union lending their support to the campaign to try and prevent this extradition. And as Alan alluded to, consider that Julian isn't a journalist. So let me just talk a little bit about some of the things that we learned from the extradition hearings that I think can be used to take conversations about this into a slightly broader, more general audience, in the hope of bringing people over to our point of view. The first, and just to elaborate a little bit on what Alan said about the risk that this poses to journalism, it's really interesting actually to start with what's known as the second superseding indictment, which is where the United States government lays out its case against Assange. There was a first indictment, which is a very short one, but the second superseding indictment, which was laid down in May 2019, and you can go and look at it very easily on the American Ministry of Justice's website. It sets out these 18 charges, which the vast bulk of them describe, as Alan said, processes that most journalists do all of the time, seeking out and cultivating links, helping those links to understand, those contacts to understand what information they have that might be useful, finding ways to discreetly pass information over and to cover their tracks as they're doing it. These are, people revealing corruption or incompetence or malfeasance in public office, who want to do something about it and want to share those stories with journalists to try and make a difference. These are exactly the kind of things that journalists are doing every day to try and bring those stories to light. And the effect of Julian Assange being convicted on these charges would be to lay open the legislation under which this is being done to prosecute any journalist for bringing any kind of national security stories to light that concerns an American administration. And frankly, it creates the potential for a kind of judicial snatch squad that could be deployed anywhere on earth whenever journalists have annoyed American governments, which frankly I find terrifying. We learned a lot during the case about the legislation on which this is based, which most of the charges arise from the Espionage Act, which was passed in haste during the First World War. And for all that it's called the Espionage Act, and you imagine that must be something to do with spies, actually, by an overwhelming majority, has been used to silence internal dissidents within the United States. So it was used to imprison Eugene Debs, the leader of the American Socialist Party. It was used to imprison trades union leaders and their members. I mean, hundreds and hundreds of what you would recognize as being civil activists have been targeted using this act. But it's one that is kind of used really when administrations want to use it and when they see somebody who they feel they ought to target. So it isn't as though they're applying it universally, and never have done, but that when administrations have seen people who, for one reason or another, because people were anti-war activists or because they were labor leaders, when they have irritated administrations, they've used this very vaguely drawn piece of legislation to target and persecute them. So bringing that into the sphere of targeting somebody for journalistic activity strikes me as being deeply, deeply dangerous, and one that opens up a whole new vista of terror, I think, for any journalists who are covering national security issues. And actually, I think that its use in a kind of discretionary way makes it all the more terrifying, because if there were a blanket piece of legislation forbidding one type of reporting or another, then at least one would know where it was and could kind of campaign against it. Something that is used simply at the discretion of administrations when they become annoyed, I think has a far greater potential to chill journalism and to make people think, you know what, I mean, I could write this story, but there would be a risk. Do I want to take that risk? Well, inevitably, some people are going to decide, no, I won't. No, I don't fancy the prospect of a stint in prison of almost unimaginable length. We learned a great deal about both the prison conditions that Julian Assange would likely face if he is convicted in the United States, and the health sort of backdrop of his stay in Belmarsh, both of which it seems to me give us quite a lot of cause for concern. American prison conditions are, nobody really seems to dispute, to British ears, really barbaric. Firstly, there's the length of the sentences. It was laid out in a kind of quite disturbing, meticulous detail how this potential sentence of 175 years might be arrived at by a kind of rational totting up of, well, you know, you start off with they'd be sentenced for 12 months, but there is a national security component to this, or that would double that to 24 months, and he's a potential flight risk, or he has liaised with journalists. I mean, a whole load of little extra conditions, all of which would add months and months and months, getting to this extraordinary potential total of 175 years. I mean, clearly so much longer than anybody's lifetime, as to be almost bizarre. But then we learned a lot about the size of the cell that he would be kept in, which is about the size of a parking bay in a car park, and that almost inevitably he would be kept in his cell for 23 hours a day, that he might be released for 1 hour a day, but it would not be in a way that allowed him ever to interact with another prisoner. And in fact, many people kept under this particular arrangement are, you know, they're offered their hour out at 5 o'clock in the morning or 3 o'clock in the morning, at some point when frankly they just want to sleep, which again seems barbaric. The lawyers for the American government said, oh, but there's no, you know, he won't be kept in solitary confinement. He might be kept under this program called special administrative measures, but that's not solitary confinement. And Assange's lawyer said, well, but it means under special administrative measures, he'll be locked up for 23 hours a day and won't be allowed to see any prisoners. Yes, that's right. That's absolutely right. But that surely is solitary confinement by any reasonable definition. So no, we don't call it solitary confinement, so you can't really technically classify it as solitary confinement. Well, that's a kind of crazy sophistry, you know, that I find quite disturbing. No less disturbing, during Julian Assange's time in Belmarsh, he spent 6 or 8 months, I think, I'm sure Jen can tell us precisely, in effective solitary confinement in the Belmarsh medical wing. And what's very obvious, because actually, you know, he had quite a lot of very forensic medical examinations, which were intended to inform these extradition hearings during that period. And it's very, very clear that during his period in solitary confinement, his health, his mental health and his physical health really, really, really deteriorated at what seemed to me like quite an alarming rate from what we learned. And then in January, I think, he was finally put back among the general prison population and quite clearly started to get better. I mean, he still has some quite significant issues, but nonetheless, being back with other prisoners had helped things. And it seemed incredible in a way that on the one hand, we were discussing the effects that solitary confinement had had for less than a year on somebody's health, and at the same time contemplating the fact that he might be put into a penal system where almost inevitably he would be kept in much worse conditions for decades and decades and decades. I mean, we learned lots of interesting things about how the files, the diplomatic cables and the war logs came to be released to the internet without, well, with a password that had appeared in a book written by 2 Guardian journalists who imagined that it had long since gone out of date. We learned a great deal about the forgive me, I've lost my stream. Let me return to just speak briefly about the experience of being in court. So I think there were about 8 or 10 of us who reported the whole hearings from the Old Bailey, and a whole load of other people did it by video link. It was a weird environment in which to experience a court case. What was striking, I mean, most of the witnesses, particularly in the month of September, were ones called by Assange's defence, and the case that they laid out to me seemed extraordinarily strong. I mean, full of rich and fascinating detail, albeit in complete fairness, not a great deal of it that, if you didn't really scrape her out and you didn't really know the case, that was completely new. And I think, it clearly has been a concern among many people. Why isn't the media covering this? Why isn't it devoting more attention to that? Now, I think there are real questions to answer there, but one factor to be certain, I think, is that editors think that people are bored with it. This case has been going on for so long. We don't have really fresh, juicy details, or quite a lot of them. So the US congressman who visited Assange in the Ecuadorian embassy to, it would appear, offer a potential pardon from President Trump, that had been trailed before the hearings. So I think maybe there wasn't enough new. I mean, this isn't an excuse on behalf of the media, but there wasn't sufficient juice to keep people on the edge of their seats, and I think that is an issue, because to me it seems that the potential risks of this are so great that we have to find ways of getting the issues into the general conversation. It's why, as I say, going through all the little strands of interest that there are from the hearings and finding ways to take those out to a broader audience, to me seems to be a way of trying to get people to talk about the case, trying to get people to talk about press freedom and the legal context within it, which it exists more generally, and to give consideration to the sorts of issues that Alan was talking about the potential revision of the Official Secrets Act. It's by taking it out beyond the circle of people who have followed every twist and turn and who have been involved in the campaign since the beginning, and taking the conversation to a more general population. To me, that seems to be the best way that we can develop the campaign and to try and involve more people in it, which is why the NEJ has been doing this work, why we're running this meeting tonight.
Thank you very much, Tim. I think that gives a sense of what it was like to be listening to pretty horrific. And remember, going back to what Alan had said, that the crime that has been committed here and the conditions under which are now being endured for that alleged crime is journalistic activity, regardless of how one's views of aspects of anyone's career. The level of barbaric treatment in a modern democracy for someone whose sin has been to expose a truth or truths is something which we as journalists can never be bored about. And it is our function, and I accept it as a challenge, but it is our function as a union to develop a strategy to engage those who are bored, because the consequence of not doing so is far too great. Jen Robinson has long been the most identifiable member of Julian's legal team. She has advised WikiLeaks since 2010 and was present at many of the moments who have been critical to the current case, which I'm sure she will talk about. She initially studied law in her native Australia and was called to the English bar in 2016 when she joined Jeffrey Robertson's chambers. Since then, she has acted for major publishers such as the New York Times, CNN, and Associated Press. She also worked on the case that established that the Pope and the Vatican were responsible for crimes against humanity as a result of sexual abuse within the church. And we're honoured and pleased to have Jen here tonight. Over to you, Jen.
Thank you, Seamus. And can I first say thank you to the NUJ and to your umbrella union, the International Federation of Journalists, and just to emphasise how important it is to have your support in this case, and the IFJ's support, and of course your sister union in Australia, the MEAA. Also, thank you to Tim in particular for covering the trial and for being down there all of September in the Old Bailey. It was a pretty depressing situation. I think it's hard to underestimate how stark the injustice is in this case. We are dealing with an Australian citizen and a publisher, whether you dispute whether he is a journalist or not. He's a card-carrying member of the MEAA and the IFJ, so his own union recognises him as a journalist. But someone who is responsible for some of the most significant publications of the past decade, publications for which he's been nominated for the Nobel Peace Prize for revealing evidence of war crimes and human rights abuse, and for which he won the Walkley Award for Most Outstanding Contribution to Journalism, Australia's Pulitzer. It is for those precise publications that he sits in a high security prison here in the UK, facing an extradition to the world's supposedly other great democracy, the US, for those same publications, where he looks like, as Tim puts out, not even looks like, is very likely to end up in a supermax prison where he'll be held in incommunicado detention in an effective life sentence, where it is clear from medical evidence he will very likely take his own life. I don't know how else to summarize this case, but I thought this evening what would be most useful is to, from one of the legal team's point of view, is to just outline quickly for you what the process is and what's next, give you a brief outline and summary of our defence arguments. But thirdly, and most importantly, is to focus on the free speech aspects of this case and why it's so important for you as NUJ members, which Alan very helpfully touched upon and outlined. And I want to dig a little bit deeper and outline some of the evidence for you about why this case is so terrifying for journalists, not just in the US here. And finally, if we have time, to give you some highlights of the evidence, and just to say now, immediately, for any of you who are interested, many of the witness statements were in fact made available to the public by the court. So if any of you would like to have access to them or are interested in any particular statements that I've mentioned this evening, I'm very happy if you email me that I can send them to you. So just in terms of the process, as Seamus indicated at the outset, we had a hearing in February for a week, which was opening submissions, and then a full month of evidential hearings in September. We are in the process now of finalising our closing submissions as in the defence, for the defence for Julian, and there will be there'll be no closing arguments. It's all going to be written, and a judgment will be handed down on the 4th of January. It has already been made clear from both sides that whatever the outcome of that judgment, that there will be an appeal, and any appeal, if we get permission to appeal, will be heard, unlikely to be heard until in the summer. But of course, if everything goes badly and we're denied permission to appeal, Julian could be extradited in the coming year. I think it's important to think about too, before we think about the process looking forward, what it is that Julian has already been through in this process. And I talk about it as punishment by process. I walked him into the police station in December 2010. And since that time, he has been under some form of restriction on his liberty, where we were always concerned, our primary concern was about this very outcome, which is a US indictment for the publications in 2010 and 2011. So he spent time in prison, time in house arrest, almost 6.5 years in the Ecuadorian embassy, and now 18 months in Belmarsh, a high security prison, where Tim outlined he spent significant periods of time in isolation and healthcare. And I can tell you, as someone who visits him, how disturbing it is to see, for me, to go into a high security prison through all that security to see a publisher. And I watched personally the impact upon his health and that decline. I went in there some days to see him, and he could barely hold a conversation. His situation was so dire. And that's before we even start to think about what he faces if he's returned to the United States in terms of an effective life sentence in a supermax prison. In terms of our arguments, I'm not sure how many of you have read the indictment, but I absolutely recommend it. There's been a number of them now. We've now got the second superseding indictment, which is the third indictment. But we are making a number of different arguments in terms of, both in terms of the unprecedented and political nature of this case, A number of our arguments relate to the abusive process that this case is, but also we're raising statutory bars to extradition under the 2003 Act. In terms of abusive process, we have three major arguments. The first is that this case, the espionage, he's charged under the Espionage Act, which is a typical political offence. This extradition request is requesting his prosecution under what is a classical political offence, which is prohibited under the terms of the US-UK treaty. And we say that it's an abusive process that the United States is seeking his extradition. Now, how can they do that? Because even though it's prohibited by the treaty, Parliament hasn't implemented that in our domestic statute. But we say that the US, by seeking to exploit that difference between the US and the UK, it's an abusive process to seek his extradition for that. And I think you'll see this argument feature a lot, and it's coming up a lot in the commentary because people are very concerned about the imbalanced nature of the US-UK extradition treaty. The second abuse argument relates to the ulterior political motives that we say sit behind this case. This is not a good faith prosecution. This is not about prosecuting a criminal offence and criminal justice. This is a political case that has been driven by the Trump administration. We now know that the Obama administration took a decision not to indict Assange. There was no indictment until the end of 2017. That this is part of the Trump administration's war on whistleblowers and journalism. We know this is a president who calls the press the enemy of the people, and that this was pursued for ulterior political motives. We also, as part of this argument, raised the evidence which I gave about the US congressman coming to offer a pardon deal, which showed the political nature of this case and the fact that the Trump administration was, at least what we were told, willing to make a deal to make this go away if it suited him politically, which reinforces the point that this is a politically motivated prosecution. The third aspect of our abuse argument is that the US government is fundamentally misrepresenting the facts in their indictment in order to justify and to present this as an extradition crime. And this gets into some of the interesting arguments, some of which, and evidence, some of which Alan touched upon. The first, we say that the US government is misrepresenting that Julian materially assisted Chelsea Manning in accessing national security information or solicited that information. And some of the evidence that's relevant to that and why this is not true is that, of course, we say Chelsea Manning herself in her own trial back in 2012 said very clearly that she took a principled decision to make this material available to Julian and to WikiLeaks. She made those decisions of her own accord and took responsibility for them. We also heard from Alan, as you heard him describe, that the discussions that Julian had in terms of talking to a source, asking a source to provide information, encourage that source to provide more. These are all the kinds of conversations that journalists have all the time. Another one of the key misrepresentations in the US government's case against Julian is this idea that he somehow hacked material or assisted Chelsea Manning to hack material. Now, of course, this is, I think, also one of the points at which many journalists seek to distinguish Julian from typical journalistic activity. But of course, it is important to note that there is absolutely no evidence of hacking in this case, that the conversation that Julian had, or allegedly had, because there's not proof that it was in fact him having the conversation, but the chats talked about trying to help Chelsea protect her identity in accessing the material. And of course, we heard evidence in court that showed that Chelsea Manning had access to all of this material and didn't need to hack. She had access to this as part of her role as an intelligence officer. The final one that I think is really important in terms of the misrepresentations of the US government is that Julian somehow recklessly disclosed the names of particular individuals and put people at risk. And as Alan said, there is absolutely no evidence that any individual was physically harmed as a result of these publications. We know that as a result of evidence given by US military sources, General Carr in Chelsea Manning's proceedings back in 2012, 2013. After extensive research, 120 counterintelligence officers couldn't find one single person who had been harmed in Afghanistan or Iraq as a result of those disclosures. In the evidence in this case, even on the US's own affidavit that was put before the court, which we were not able to cross-examine, by the way, there was no evidence and no suggestion that any particular individual was harmed. So all these years later, they still haven't been able to find someone. But in any event, as our evidence showed, it's obvious that Julian did not recklessly disclose that information. WikiLeaks took significant steps together with The Guardian and other partners to redact that information. The publication had been redacted and significant resources were put in place for harm minimization in relation to each of these publications. And that ultimately, when WikiLeaks republished the unredacted cables, that material had ended up in the public domain as a result of unforeseeable events that WikiLeaks and Julian could not have put to a stop, which involved the publication of an encrypted password by a Guardian journalist, which was outside of the control of WikiLeaks. And that Julian, once that material came into the public domain and others started publishing the material because they could access the encrypted file with that password, Julian took steps to try to injunct that from happening, to injunct the publication of information, and even put the State Department on notice of the concern that this was going to happen. So it is just false to say that he recklessly put anyone at risk, and two, did so recklessly. In terms of our statutory bars offences, we are arguing that it's politically motivated. We're arguing that it's unjust and oppressive to extradite him given the lapse of time, that he will not get a fair trial if he's returned to the United States. We are making key arguments on the basis of Article 10, free speech, and Article 7, which raised the point that Alan raised earlier about this, the fact that the law has never been applied in this way, that Julian ought to benefit from free speech protections for his work, which is clearly journalistic activity, which is of the nature that journalists engage in all the time. But also, this is so unprecedented. The Espionage Act has never been applied in this way against a journalist or a publisher, certainly not a foreign journalist. And in circumstances where the United States is saying that he will not benefit from First Amendments because he is Australian and because he is a foreigner and not an American citizen. And finally, we're making arguments on Article 3 because of the nature of the prison conditions that he's going to face once returned to the United States. And you heard from Tim about the special administrative measures that he'd be under, which is effectively incommunicado detention. I think it's really important, just touching upon the free speech concerns, to look at what the indictment says. The prosecutor continually misrepresented or tried to put to our witnesses throughout the trial that this is not about publishing classified information, it's about putting people at risk. But as we point out, if you look at the indictment, this indictment covers receipt, possession, and publication of classified information. When it was put to one of our free speech experts in the case, well, this is not about publication. He actually said, well, it is about publication. And in fact, it's worse because you could, under this indictment, the precedent that you're setting with this, any journalist who receives information and possesses it, but doesn't even publish it, can be criminalized, which is the criminalization of national security journalism. And would ultimately end up, Trevor Tim from the Freedom of the Press Foundation said, would be the end of national security journalism. I want to just emphasize how unprecedented this is, both in terms of the Espionage Act and the Official Secrets Act in this country. Now, this is why it's important for British journalists to be aware of this, because not only are we dealing with an Australian citizen who looks to be extradited from this country for publishing truthful information about the United States. Now, what that means for you as journalists who will no doubt over the course of your careers potentially receive classified information about the United States, but also because in finding for his extradition, the judge here has to find that this would be a crime in the UK under the Official Secrets Act. So in a sense, by seeking his extradition, the United States is seeking to lock in an interpretation of the Official Secrets Act in this country to show that what WikiLeaks did and what Julian did with this information is a crime in this country. The kinds of conduct that Julian engaged in, and Alan explained this incredibly well when he spoke earlier, that the US is seeking to criminalize. What they're trying to do with their prosecution strategy is break down what you all understand, and we all understand as an important distinction, which is prosecuting a source who has obligations to government not to disclose information, and finding a journalist to be complicit in that unlawful act by the source by having communications with that source. And you see in the course of the correspondence and the chat logs between Chelsea Manning and the person who is alleged to have been Julian, he uses language like, okay, great, or curious eyes run dry. As Alan said, any journalist worth their salt would be having exactly that conversation. And if that kind of conduct amounts to conspiracy with the source to release that information, then Bob Woodward would absolutely have been prosecuted for his communications with Deep Throat. That's why this case is so dangerous. It is not just about publication, it is also about receipt and possession. Just quickly, if we have time, and I'm not sure if we do.
You do, yes, yeah.
I wanted to highlight for you some of the key evidence, which I think was really important and interesting. And it is a shame, as Tim and Alan both touched upon, that there wasn't sufficient reporting of this trial. There were many important moments through the evidence that didn't get the media coverage that it deserves. One of my favorite moments was having Daniel Ellsberg cross-examined, obviously of Pentagon Papers fame, who spoke so eloquently. He's still so sharp for his age, it's quite remarkable, about how he was vilified at the time. And then suddenly, as Julian came forward, Chelsea Manning, Snowden came forward, he was suddenly became this revered hero, you know, of principled leaking and the right kind of leaking, in order to somehow make Julian and the others that have since come look like they've somehow done the wrong thing. He also spoke very eloquently about the kind of abuse that he suffered that resulted in his case being thrown out with prejudice as an abusive process during the Nixon administration. And many of you will remember the fact that he was heavily vilified by the administration, but also his psychiatrist's office was broken into. And this kind of abusive process was sufficient to have his entire criminal case thrown out at the time. As Daniel Ellsberg said in the case, and as we heard from other expert witnesses, what we've seen in Julian's case is far worse. So I have been targeted as one of his lawyers. We know that our legally privileged correspondence has been seized by the US government. We know that our legally privileged meetings have been spied upon, and that material has been sent to the United States. We know that his doctor's appointments have been monitored. We know that all of his legally privileged material that was in the embassy was seized by the United States. These kinds of abuses should be sufficient to have the whole case thrown out, and yet the prosecution continues. I think what will be interesting for your member, for the NUJ, is also the evidence that we heard from journalists. So we had Nikki Hager from New Zealand, John Gertz, based in Germany, and Stefania Marizzi, an Italian journalist, each of whom had, there were other journalists that gave evidence, but these were the three that gave live evidence, so were cross-examined by the prosecution. Each of them gave evidence about the process of working with WikiLeaks, the security procedures that were put in place. And importantly, Nikki Hager and others spoke about how you cannot distinguish in terms of the journalistic activity what Julian and WikiLeaks did and what they do all day, every day, which is, again, underscores why this case is so dangerous. For me as a human rights lawyer, the evidence that I enjoyed the most was from Clive Stafford Smith, and we also had a written statement from Khalid al-Masri, who is a victim of US and CIA rendition and torture, both of whom talked about the importance of WikiLeaks releases in terms of revealing US war crimes, torture, extrajudicial killings around the world, and how important that was, for example, in Khalid al-Masri's case, as evidence before the European Court of Human Rights. So I think in terms of the evidence, it was incredibly important as a historic records, like a reset of the historic record, I think, debunking some of the myths and widely reported inaccuracies and misinformation about WikiLeaks activities, about what Julian and WikiLeaks actually do, about the importance of these publications, and about why this case is so dangerous, not just for the First Amendment, but for journalists in this country, given the approach that this will mean for the Official Secrets Act. Just in conclusion, I know that you've had some difficulties at the NUJ in rallying members around support for Julian. And as a lawyer, I just want to say one thing about that. It is a dangerous, dangerous position to take as a journalist, to be defining who is and who is not a journalist, because there is no clear definition. And that's why it's so important that free speech protections, which I engage in and advise people about all day, every day, are about protecting journalistic activity. So the whole debate about whether you classify him a journalist or not is a complete red herring. What is important is that WikiLeaks engages in journalistic activity. That is what attracts Article 10 protection, and that is what should attach First Amendment protection. So I think two things that I would love to hear from people who are attending this call is, One, why you think the media has not properly been covering this, and what's causing that, and what more the NUJ can and should be doing, and how we, particularly as me as Julian's lawyer, how I can facilitate you and provide you with the materials you need to convince whoever needs to be convinced about why more needs to be done about this. But thank you very much for having me.
Thank you very much, Jen. And I think that was really, really comprehensive. And you asked if you had time, I think we could listen to you for another hour and we still wouldn't get everything that you can do and say and tell us. The format is that people are submitting written questions. We don't have the technical capacity to. We didn't set it up anywhere where people could contribute directly to debate tonight because we weren't sure how many we were going to have. But there's a few things I see happening before I put the questions. One is that we will be encouraging our members as a result of information tonight to go back and to discuss this issue with their own branches. We have an NEC meeting coming up in our National Executive Council in 2 weeks' time. And this is part of a process of re-engagement with our members. We did not have the benefit of the delegate meeting this year, which would have given our campaign the boost that we needed. But because of COVID, we didn't have that. But I think that this is timely. We have an executive meeting in 2 weeks' time. We have an Irish Executive Council meeting. So there are a number of things coming. Few questions have come in, and a few of them have been directed to Alan, and they relate to a similar question. So I'm going to put Tariq and Nick's question to Alan on the same subject, which is, if I can summarize it, is that Alan himself as editor worked with Julian and has been supportive, but there are a number of people, including Julian Cook, who say that The Guardian as part of the problem in putting, is in the frame as part of the problem. Cook claims that it was a Guardian staffer was the first to publish WikiLeaks password for official US cables, not Julian. And other journalists from The Guardian have been named and criticised. And the question has been, does Alan want to comment on that? And how does he feel that undermines The Guardian's authority in this issue? So, Alan, I don't want to come in on that.
Well, first of all, it's a matter of record, which we can't unwrite the historical record that at the point that WikiLeaks decided to publish a great deal of the material unredacted, all 5 editors issued a statement saying they disapproved of that. And I think the reasons are pretty obvious, that we had spent months trying to redact material and handle it responsibly. So, of course, we were dismayed to see this material in the public domain. On the issue of the culpability for that, I don't think it's helpful for me at the moment to weigh in or for either side to point fingers at each other. Julian's freedom and even life depends on this at the moment, and I wasn't there in court for evidence that was given, but I understand it's a very complicated position about how some of that material appeared in the public domain, not initially through Julian and certainly not by The Guardian. So I think I would rather wait and read some of that material before doing anything which might be unhelpful to Julian's case.
As a union official, I am regularly told by the former chair, was regularly told by the former chair of the Irish Labour Court that the worst thing one should do in these situations is try to unring a rung bell. And I think that is the message that I'm getting from Alan, which is that the priority here has to be built around what Jen has identified very eloquently as being a very sacred journalistic principle. Tim, I know you wanted to come in. Yeah.
Well, just say, I mean, I've heard repeatedly, The Guardian milked Julian Assange dry and then hung him out to dry. And I think it's a kind of cartoonish misrepresentation that really doesn't help. there is this kind of extraordinary period during which, as Jen said, huge efforts were made to redact the information. At the same time, copies of the entire encrypted file were kept in numerous places around the world, some of them publicly accessible, through what seems to me to be it clearly didn't occur to the people who published the password that it was something important, and indeed it appeared in a printed book that was available for a good 6 months before anybody really put two and two together. Essentially, there are a series of cock-ups that have, for which a whole range of people have some culpability. Julian Assange among them, but they are all culpabilities of cock-up that happened under quite extreme circumstances of kind of cyber attack. And having heard them discussed in kind of the most minute detail at both the Old Bailey and at Woolwich Crown Court in southeast London, it does seem to be essentially a cock-up, and fetishizing who was to blame seems completely unhelpful to bringing people on board in terms of what really, really matters, which is the free speech issues.
Yeah, a few questions have come in about, and a few comments on both chat box to me and to the Q&A about how do we engage and how do we get our members to engage more fully with this? And I suppose, Alan, as a former newspaper editor, you can put yourself outside of this story and looking at it in general. How does one engage both the public and journalists in this matter, and what are we doing wrong? What is the failure, or why have we failed so miserably to engage the public on this issue?
Well, as I say, I think there is a attitude which I can't really explain amongst British journalists when it comes to national security. I think it's an unusual culture in this country. The D-Notice Committee is part of it, and the rather obscure practices that the intelligence agencies have in who they will deal with and who they won't deal with, and the fact that it's very difficult to sort of ring up a press officer for MI6 or MI5 or GCHQ, as far as I know, unless things have changed in the last 5 years, and ask questions in the way that is absolutely standard in the US. I mean, the contrast when we had the Snowden documents between the American reporter's ability to ring up the CIA or the NSA and say, look, we've got such and such a document. We're going to publish something on it. Do you want to have a conversation? And as often as not, you would be put through to a desk officer who would say, well, let me just get that document. Okay, look on page 7, there's something there which we would rather, which we will explain to you why that's problematic. And you could have a grown-up conversation with the aim of minimizing harm, which of course is in everybody's interest. The contrast between that and the British authorities, at least, I mean, I would say 2/3 of the way through that story, when their policy was, we will neither nor confirm nor deny that there is such a document, i.e. we're not prepared to discuss it. So these are the different cultures that exist between the coverage of national security issues. So how do you get people more engaged? Well, I think you have to remind people of the fantastically important stories that emerged as a result of this partnership. You have to emphasize that if this goes through, it's going to be very threatening, not just to national security journalists, but I think to a range of other investigative journalists who could find themselves in jeopardy. And I do think, to repeat what I said earlier, we have to listen to extremely wise, experienced, legendary figures like James de Gaulle, who helped produce the most ringing landmark judgment of all in the last 40 or 50 years, when he signals this flag. I mean, the Pentagon Papers case has meant that the American authorities have never since, that I'm aware of, tried to injunct the publication of material like this. I mean, it would be unimaginable, even for Donald Trump, to march into the Washington Post newsroom in advance of publication and say, don't publish this. And yet in the Snowden case, that's exactly what the British Cabinet Secretary did. He said, if you don't stop publishing, we will do unmentionable things. And everyone knows about the destruction of the computers and why we had to transfer our reporting to the US. So I do think the issues in this case are of wide and general concern. But of course, I understand that the press, the media generally are in an economically beleaguered state, and it's harder to fight these kind of battles than it was maybe 10 years ago.
Next, that leads, I think, neatly into the next question, which I'll from Matt Salisbury, which I'll ask Jen to comment first, and in doing so, I might put Matt's second question. He asked two questions. The one which I think all panelists would comment on is, would a Biden victory next month be likely to have any impact on what happens? That's the crystal ball question. And the other question, Jen, is the case likely to go to the High Court or Supreme Court? And can we tell what's likely to happen there? So.
Sure. Well, first, in terms of the appeal process, the next level of appeal after the Magistrates Court is to the High Court. So it will, well, we suspect both sides have indicated they will appeal, so it will likely end up in the High Court, presuming permission to appeal is granted. And we do think that we have some strong arguments that the Supreme Court could be interested in. But of course, that all depends on what the judgment is in January and what that looks like and what happens afterwards, because of course we could raise new evidence and arguments on appeal with the changing circumstances. As to whether a change of administration would make a difference, I think it's important to remember that Joe Biden did call Julian a high-tech terrorist. So whether he would get a fairer hearing by a Democrat administration is an open question. But certainly the Obama administration had chosen not to indict, and one would hope that the Democrats would take a better free speech position, but that remains to be seen. And of course, the fact that people are asking this question at all goes to show just how political this case is.
Tim, do you want to comment on that?
Well, I am perhaps slightly more hopeful, but not on the basis really of deep knowledge of American prosecutional policies. It's unusual, I guess, to British eyes, how nakedly politicized prosecution is in the United States. And I was left, it seemed to me very likely that much of the impetus behind this is probably Mike Pompeo, who led the CIA before his current appointment. And it would certainly be, my hope would be that a change of administration in the United States might have a transformative effect on how this is pursued. But clearly, at every stage, without knowledge of what's going to happen in the future, which none of us have, one can only try and campaign with what knowledge we do have and where we are at the moment, with the utmost energy and sort of initiative.
Alan, have you any thoughts on Biden, or hopes for what would happen in the event of Biden being elected?
Is that for Jen or me?
I think Alan didn't hear that.
Oh, sorry.
In general, yeah, for you, Alan. Yeah, just I'm wondering about the implications of a Biden victory on this, and indeed on press freedom.
Well, I mean, press freedom, no question. that we're better off without Trump, who's done more than any Western politician I can think of to try and delegitimize the work of journalists, place journalists in danger, to blur the lines between truth and untruth. I mean, it's been an absolutely disastrous period, and all the more so because he's the so-called leader of the so-called free world, and what's happening in America has an enormous ripple effect and legitimizes the behavior of other regimes. So, you know, the sooner we get rid of Trump, the better, from the point of view of journalists and what we do. I don't know about Biden. I mean, my memory is that initially, at least when we did the Snowden stories, Biden and Obama behaved quite reflectively, and you know, they ordered not one but two official commissions to look into the allegations, and they had a body that just looked at the privacy implications of and civil liberties implications of surveillance. So the Obama administration was much more measured in its response to Snowden, and the initial response to Assange was more measured. So I can't help feeling that if Trump and Pompeo and their ilk were taken out of the picture, it would improve the prospects. But I'm sure Jen is closer to it than I am.
Jen, do you want to come in on that again? Are you okay? Asking if you want to respond in any way to that.
No, I don't think I can add any more.
Yeah, there is a question that has been asked from panelists that if Julian had stayed a British citizen, would it be easier to argue in the instance of Anglo-American partnership for a pardon, given that the UK are about to do a no deal with the EU?
Well, I guess the first thing is that he's not a British citizen, he's an Australian citizen.
Yes, the question was if he had stayed a British citizen, but I don't know if he ever was.
No, he's not. He's an Australian citizen who was given Ecuadorian citizenship, then stripped of it, and retains his Australian citizenship. You know, we've reached out continually to the Australian government to take action on this case, and for the same reasons that Gemma raises there about the importance of the Anglo-American partnership, the Australian-US partnership is incredibly important. We're part of that special relationship, and yet the Australian government has refused to take a strong stance against this taking place. And I truly believe that if the Australian government took a much stronger position, given our relationship with the United States, then I think we wouldn't be where we are. And certainly, you know, that was part of the reason why he sought asylum. The Australian government was not going to do anything, and it wasn't clear the British government would do anything. I'd be interested in what NUJ members could potentially do in terms of lobbying MPs here. Obviously, the last time Boris Johnson was asked a question about this in Parliament was when Jeremy Corbyn was still leader of the opposition and asked about the imbalanced extradition arrangements, about the Council of Europe saying that Julian ought not be extradited, and what Boris Johnson thought about that. And what was interesting is he said journalists and whistleblowers ought to be protected. And I do think it's interesting to see where you think the British politics around this sits. But of course, because he's not a British citizen, it's harder to garner.
Yeah. Yes, I think that question, and I'm going to throw it over to Tim in the last few minutes, because we had said we're going to finish by 8:30, and as I said, this is the start of the process, is where we go from here, NUJ wise. And I think the use of the parliamentary group, the NUJ has quite an effective parliamentary group, which is a cross-party parliamentary group. I think that strikes me as one. And I suppose the other question I would think out loud is whether or not the Irish government has a role, and whether the NUJ in Ireland, which is well connected across the parties, could have and could play a role both in terms of EU and also Council of Europe. So Tim, and then we might take final comments on the where we go from here piece from Alan, and then Jen to wrap up. So Tim, yeah.
I mean, I think, and you know, I'm in the market for anybody who's got a better strategy or a better idea, but taking the conversation about why this is important into as many forums as we humanly can seems to me the task in hand. So yes, I think it's worth raising with parliamentarians. Yes, I think it's worth raising with other trades unions. Yes, I think it's really worth raising wherever people come together. Yes, I think it's worth raising in other jurisdictions, because something that happened, it's as much chance as anything else that this is happening in the United Kingdom. It could just as well be happening in the Irish Republic or in France or in Spain or anywhere else. So I think the more people who start looking at the details of this and thinking about the implications of it, the better. I just want to mention one small thing that I was very struck with during the hearings, and again, it's a way of taking this conversation to people. We heard lots of evidence, as Jen said, about how the Ecuadorian embassy was bugged by this firm who, as it turns out, were almost certainly working for the CIA. They were certainly supplying the material that was deliberately recorded the meetings between Julian Assange and his lawyers and was being handed to the CIA. And we heard that process explained in very considerable detail. We heard from the people who had actually, the technical people who had installed the bugs, and people who'd seen the material being handed over. And the prosecution lawyers made no comment on that. And they were pressed on, well, why aren't you, do you not want to cross-examine them? They said, well, our client has given us no instructions in respect of that, which I think you can really take as meaning that actually all of that is true. It's true that the CIA bugged a foreign embassy in London to try and abuse legal privilege. That to me seems like an extraordinary thing. And getting people talking about things like that in as many forums as possible, I think, is the way to make this an issue that people recognize as having greater importance to their own work and their own lives, and for their level of outrage and concern to develop and grow.
Right, going to go to Alan on that issue of where next. I think what Tim is saying echoes your opening comment, which is that what we need to get people to realise that this is about something more than an individual. So within that context, Alan, what would your ask from the NUJ be at this stage?
Well, I think the NUJ ought to frame it more broadly as part of an attack on journalism, which is going to affect all journalists. I mean, I was astonished. I can't remember exactly. It was somewhere around about 2011 to 12 when it became apparent that the government had no compunction about coming between a journalist and his source and intercepting, listening into that. I mean, that had been a sort of a sacred thing, much as Jen has referred to the fact that, and Tim have talked about this astonishing thing that the privilege between a lawyer and a client has been completely junked in this case. By the way, the government at the same time slipped in other things, the relationship between a GP and a patient, or a priest and a communicant, or an MP and a constituent. All these things which, it was unimaginable 20 years ago a government would award itself the right to start listening into those kind of relationships. And to do the NUJ credit, they were onto that issue, but I don't think that the general membership was angry enough about it, because once you start getting in between a journalist and their sources, that's going to do immense damage to journalism. So I think we have to say there's that there's the impending nastiness that's about to slip down the slipway, which I have little doubt will be that they're just waiting for some terrorist atrocity so they can then announce a new terror bill, and they'll slip all this stuff in about journalists, because they're very clever at choosing the moment to do these kind of things. And the Assange case is part of this too. And I think all three of us are saying, whatever you think of Assange and his status, this has far-reaching consequences, as do all these other things that governments are doing, and which I don't think journalists are making enough noise about. And the reason that it matters is that it's up to each generation of journalists to fight the legal battle of their times. And the fact that I couldn't be injuncted in the US for publishing the Snowden material was down to the battles that James Goodall and the New York Times and Ben Bradley and Abe Rosenthal and the people who are running the New York Times, the Sulzbergers, the Grahams, you know, that generation of people who fought that battle has benefited journalists for 40, 50 years later. And so I think the duty falls on our generation of journalists to fight the same battles, because freedom of speech is never a done deal. It's something that is only kept alive by fighting. And so I think I would pitch it to members that this is their kind of duty to others and also to future generations of journalists. And it matters really around the world as well, that if British and American journalists are seen to shrug when something like this happens, just imagine what's going to happen in Turkey or Zimbabwe or Pakistan or Saudi Arabia or any number of countries where people look at what used to be the the leaders of free speech and think, oh well, if they don't, if even British journalists can't be bothered to get too worked up about this, just imagine what we can do.
Jen, and I'm just going to, I can't ignore a question from someone who also stood up for press freedom, and that's Bill Goodwin, who asked, so in giving you the opportunity to sum up, just also Bill asks about whether or not the process and the conduct of proceedings was fair, particularly the exclusion of NGOs from attendance as observers and the manner in which attendance through the courts, the case was managed in that sense. Yeah.
Sure, I'm happy to answer that. In terms of the attendance and the access, I mean, unfortunately, British courts have not been great across the board, generally speaking, about access for journalists. For example, allowing live streaming, though there was some live streaming in this case. So some people were able to access this from abroad because of the extraordinary circumstances we're in with COVID. But it was incredibly difficult to get NGOs in. And I think that really affected the amount of coverage and reporting that we would ordinarily have had to see. We would ordinarily have expected to see. But as to the issue about the fairness of the process here, I think, well, that remains to be seen. But one of the key things that I think is really important that I didn't touch upon and Tim mentioned was the second superseding indictment. So this case is unprecedented in terms of the way they're pursuing a publisher, the way they're using the Espionage Act, the way they're pursuing a foreign publisher, which is important for all of you, a foreign journalist being prosecuted, and the US government saying that because you're a foreigner, you don't have First Amendment rights. So you will exercise jurisdiction over you and bring you back to face prosecution, but you don't benefit from constitutional protections. Is the extraordinary way that they're pursuing this case. So Julian was served on the morning of the hearing, halfway through the case, 18 months after the case had opened, after our evidence had closed, after legal arguments had closed. He was served with a new superseding indictment with new allegations, which the US now says could form the basis of separate criminal accusations and prosecution in the United States. Now, we didn't have time to address it. We weren't able to bring evidence about it, and yet that's still potentially part of the case. So there are some real due process concerns. Certainly one of our QCs said that our combined legal team in all of the experience had never seen a case in which a government had sought to shore up its case against a defendant as they've watched the case unfold and bring in new allegations at such a late stage. So I think it's worth, as NUJ members, to follow that development. But just to wrap up briefly, I can only reiterate what Alan has said and what Tim has said about the threat to free speech that this is. It's not just about Julian, it's about what this case will mean. And as we have been, I feel like a broken record, I've been saying this since 2010, as Alan will remember, that the journalistic community, the mainstream media needs to stand with WikiLeaks, because the criminal investigation and any future indictment, we didn't know what was going to come then, but we suspected it. You cannot distinguish between the journalistic activity that WikiLeaks has engaged in and what the rest of the media engages in. And the the strategy that the media, many used to somehow other WikiLeaks and put Julian over and WikiLeaks over there as this other sort of thing, not a journalist, not responsible journalism. A dangerous strategy, because now we have the indictment. You can see that this indictment absolutely covers news gathering activities that all of you engage in all the time, which is precisely what we warned of. And to think that somehow the discretion won't be used once this precedent is set against you is frankly naive, because look at the way the world is developing. And just finally, Julian is a card-carrying member of the Australian Media Union, of the equivalent, your sister union, the MEAA. He has an IFJ journalist card. Whatever you think of him and whatever you determine is the definition of a journalist, he is ultimately a member of your union and deserves that solidarity. So even if you don't disagree with us on the First Amendment free speech issues, I think the unions do have an obligation to their members. So I hope to see more action in the future.
Yeah, thank you very much. As Assistant General Secretary, I can assure you we're very aware of that obligation. I'm sure that Yates did not have WikiLeaks in mind when he asked the question, how can we know the dancer from the dance? And we cannot talk about defending journalistic freedom, but not defending a journalist. We very deliberately do not have a definition of a journalist within. We don't want a legal definition of journalism. It would be extremely unhelpful. And I suppose I'm going to engage in the Irish habit and the Biden habit of closing with another quote from Yeats, and I hope that we can prove Yeats wrong. Though in looking at some of the critics of the NUJ and of those who seek to defend defend Julian and being attacked for it, like as Tim mentioned, I'm reminded of the poem The Second Coming, where Yeats said, the blood-dim tide is loosened, and everywhere the ceremony of innocence is drowned. The best lack all conviction, while the worst are full of passionate intensity. My hope from tonight would be that we had more action and less passionate intensity, or that if we are passionate intensity, it would be harvest for the good of press freedom. Because I think, as has been said by all of the speakers tonight, we really do need to see the big picture here. Because if we don't see the big picture, it will be too late for all of us. And I'm very struck by Alan's description that we are the custodians of the tradition. And we must uphold that tradition and enrich that tradition. And on that note, I just want to thank Jen, Alan, and Tim. I have attempted to put all of the questions to the panel. One question was an invitation. It was put twice, which was inviting Alan to condemn the Guardian coverage of the case itself. Knowing Alan's answer, I didn't bother inviting him to do that. It's a long-standing tradition of the past Pope not meddling in Vatican affairs, and I suspect the same applied to the Guardian. On that basis, I'm looking forward to a vigorous debate within our own councils, within our own chapels and branches. I was going to offer you safe home, but you're already home. Enjoy the rest of the evening, and thanks for your cooperation. And thanks also to Stuart for technical support. Good night.